So this is our second talk as part of the lecture series on constitutionalism for this academic year. We had a fairly good range of speakers last year. And I'm not sure why that happened, right? Anyway, but today's guest is Dr. Venkat Iyer, who's currently a senior lecturer in law at the Ulster University in Northern Ireland. He's clearly of Indian origin, as you can see. And obviously, he has a fair amount of things to say about the Indian legal system as well. So we didn't really circulate any of his previous articles directly on the groups. But the focus of this talk is something that was worked out through conversations over email several months ago. And initially, Dr. Iyer was interested in speaking about media law or the Indian legal system from a holistic point of view. But after some consultation with the student group, we thought it might be useful to hear about a topic on which it might be a bit hard for us to get speakers otherwise. So that's how we arrived at this focus on the Brexit process. And he kindly agreed to come here because he was spending a few weeks in Bombay at this time in the year. So without any wasting more time, I'll request Dr. Iyer to speak. He suggested that he'll speak for about 40-45 minutes, and we'll have question and answers as follow-up after that.
Thank you, Siddharth, for that kind introduction, and can I also say how grateful I am to all of you for turning up for what I would normally assume would be an extremely dull and boring topic. I never realized the extent of interest here for Brexit. I would have thought that it would be pretty low in the list of preferred topics for you, but I'm delighted nevertheless to be able to do this talk. Can I also express my gratitude to Nalsar for inviting me. This is the first time I've come to your university, and I am obviously very glad to be here. It is a short visit. I only intend to stay on for a day, but I've got to know one or two of you, and I'm very heartened by the warmth of the welcome that has been extended to me. As Siddharth mentioned, I'm going to be talking on the legal dimensions of Brexit, and I'll be speaking for about 40 minutes approximately, after which I will be happy to engage in Q&A with you. Brexit, as you know, is still in the news and will continue to be in the news for some time, for a variety of reasons. It is undoubtedly a watershed moment, a watershed development, a watershed event in British history, not just British legal history, but British political history, British economic history, to some extent also British cultural history. And it has profound implications, many of which will remain unpredictable for a long time to come. Not many people, not many experts are able to even remotely guess the exact outcome of the current negotiations that the UK government has been engaged in with Europe. And there are, of course, also implications beyond those negotiations. In terms of the here and now of Brexit, it has generated a lot of friction in British society. And it has also unfortunately given rise to a degree of bitterness in British society, which will take some time to die down. The immediate challenges, even if they are overcome, are not the only problem with what is happening at the current moment. There will of course be lessons that Brexit will hold for other countries as well, particularly countries that are contemplating ever closer union with other countries. As you know, in ASEAN, of course India is not part of ASEAN, but in ASEAN there is emerging what at the moment is being referred to as a common economic market. And who knows, there might be an occasion in the future for South Asia as well to develop some sort of a common union, whether it's political or economic. It's more likely to be economic rather than political, but when that happens, then there might be lessons that can be learned from the Brexit experience. Now, what were the triggers for the yes vote in the Brexit referendum? As you know, the referendum produced a result which many people thought was unlikely to happen. And clearly, the triggers were more than one. There was, sorry, do you need to adjust the mic? Just put it away. I'm hoping it's going to be better now. There was growing disenchantment, sorry. Yeah, okay. There was growing disenchantment with the direction of EU travel for many years now. And that obviously grew over time and grew to an extent where people have begun doubting the benefits of ever closer union. And that obviously was a key trigger for the referendum result. There was a particular ire which was directed at the what we may call the stealthy growth of the EU. A lot of what was happening in the EU was not entirely transparently stated. Because if you remember, the European Union, which began as the European Communities all those years ago, had as its primary objective the creation of a common market. In fact, any literature that you will refer to about the EU at the time of its formation spoke essentially about a common market. But that got transformed into a political project. And when that happened, then clearly public unease grew. And obviously, you can imagine there is a degree of value attached to sovereignty. And that was clearly being threatened. So the stealthy nature of EU expansion was also an important factor for the result that emerged in the referendum. Then, of course, you'll see a lot of talk about the democratic deficit in the European Union, in the European Union system. Why is that? Because decisions are taken not by elected representatives. there is, of course, a European Parliament, but the Parliament is, in most respects, powerless. Real decision-making happens at the level of unelected bureaucrats. So what you have is the Council of Ministers that makes policy decisions which are then implemented by bureaucrats. And that was also seen as antithetical to the democratic spirit. So the democratic deficit was bothering a lot of people over decades. On the domestic scene in Britain, there was growing unease over uncontrolled immigration. Now, to many of you, this might seem a little far-fetched, because you might think that Britain has a tight immigration policy, which is not true. At least it has not been true since the mid-1990s. After the Blair government came into power, they made a conscious decision, without telling the public, of loosening immigration controls. As a result, we have a situation where a large number of people have come into Britain in circumstances which made the local population extremely uneasy. There are many aspects to this problem, but I imagine that the most frustrating aspect from the point of view of the local population was the fact that the government was not upfront about what has happened. In other words, if the government had said, look, it's our policy to loosen immigration controls, which had been imposed in previous decades, then possibly people would have understood. But if you did not confide in your own people and allowed what effectively became uncontrolled immigration. And of course, there's another side to this problem, which is, in technical terms, not directly connected, but in terms of its effect, was no different. And that is the concept of asylum. In other words, the refugee issue, which if you are going to be very technically minded, you can separate from immigration. But the result, as I said, is the same. So altogether, that has been causing a lot of unease, and that also led to growing public disenchantment and the result that we saw in the referendum. And then, of course, there was the economic aspect, and that is, there was a growing perception on the part of the British public that Britain was not getting value for money by being part of the EU. Why is that? It's because the EU is a club to which certain countries contributed monies and certain other countries drew monies from. So if you want to put it very bluntly or very crudely, it is a socialist system whereby some people give money and some people take money. Now, nothing wrong with that, again, if you're upfront about it, if these rules are very clear, and also if those who take money out have certain obligations. But that was not how a large number of people saw it, particularly also because the money that went into the EU pot was often misspent. There was a lot of waste, there was a lot of mismanagement, there was also, unfortunately, a lot of corruption. Now, you may imagine that Western Europe is free of corruption, and you'd be completely wrong, because even in Western Europe, there's a fair bit of corruption. And when that happens, obviously, people do get very upset. And that is, again, a serious factor which led to the yes vote in the referendum. Now, Britain anyway has had a rather turbulent relationship with Europe. This is, if you like, in historical terms. Quite clearly, the Brits distinguished themselves demographically and in other respects from the continental Europeans. In other words, the Brits have considered themselves to be distinct and separate from the Europeans, although they had good relations with their neighbors, but good relations not to the extent of identifying very closely with the Europeans. Historically, of course, there were a number of wars that Britain has fought with European countries, and that can't be lost sight of. And then, of course, there's the issue of language, which also is quite important. In fact, oddly enough, the British people are, in very general terms, more likely to identify themselves with Australians or even Indians than with, say, Scandinavians or the French or German. Language is important, and that also contributed to some extent to the alienation, if you like, of the British people from the continental Europeans. A rather frivolous but telling example of how the Brits saw Europe can be seen from what I think is an apocryphal cartoon that appeared, a news item that appeared in a British newspaper some decades ago, which said, "Heavy fog in the English Channel, continent cut off." So you can see how the Brits perceived continental Europe to be. Now, of course, that is used as a caricature, that is used as something which shows the Brits in bad light. In other words, they are very insular, etc., etc. But it is a reality which cannot be wished away. And of course, in legal terms, and this is a serious point, in legal terms, many British people thought that the EU interfered too much with local matters. And this is something which might seem a little academic, but it does have practical consequences. European law was given primacy in Britain. I'm happy to develop this theme if you're interested and talk to you more about this. But the simple point I want to make at this stage is that in acknowledged legal terms, if there was a clash between European law and English law, British law, then European law would prevail. This is an extraordinary state of affairs, which I hope you'll be able to appreciate the import of. Just imagine if you had a union of states in South Asia, and part of that union's laws was that if there was a clash between the, let's say, for the sake of argument, SAARC, that SAARC law had precedence over Indian law. How would you all feel about it? I think there would be a degree of unease. And that is exactly what happened with the European Union. So that is, if you like, the background to the referendum. The referendum itself, as you know, happened on the 23rd of June of last year, and it was won by a narrow but decisive majority. The yes vote was not overwhelming, but it was still very clear. It was not a knife-edge decision, and to the extent that nearly 52% of the people voted to leave the European Union was indicative of the strength of feeling among the British people. Of course, it is arguable that 52% is not exactly overwhelming, but it is still decisive. In a democracy, anything over 50 would be a result that has to be accepted. Otherwise, why have a referendum? And there was, of course, wide variation in the result between the regions of the United Kingdom. So that in relation to England, the yes vote was 53.4%. In relation to Wales, it was 52.5%. Scotland was a part of the UK which voted the other way. That is to say, not to leave the European Union, and that was by about 38%. And Northern Ireland was also seen to be reluctant to leave the EU. There, I think it was 44.2% or something like that. So there was variation within the country, but the overall result was clearly in favor of leaving. And the turnout for the referendum, which is important, was about 72% or thereabouts. So again, reasonably high turnout. So if the turnout was low, then of course you could argue that only a small minority of people voted, and within that you had a relatively low margin. But it was not the case. And clearly the fact that you had about 70% of people voting made a big difference. Now, in terms of the nature of the divide, there are many opinions and there are many reasons offered why what happened. Particularly in the case of Scotland, there are a number of theories that have been advanced, because as you know, Scotland was fighting a separate battle with England and Wales, and that is actually to seek independence. But that is an issue which should not be confused with what happened in relation to the EU referendum. As to the degree of separation, clearly also there would have been differences of opinion. In other words, of the majority who voted, some would have wanted complete detachment from the EU, but some would have liked a degree of detachment that was not absolute. That is to say, we'll still keep some links with Europe, but not detach ourselves completely. Possible. But at the end of the day, in a referendum, there's only so much that you can get by way of a result, because a referendum doesn't ask you either why you're voting in favor of leaving or what exactly is the degree of separation that you're expecting when you vote to leave. So that aspect is still being discussed, and that is actually part of the big debate that the United Kingdom is having internally when it comes to negotiations about exit. In legal terms, of course, there are a number of issues which have arisen, and the situation is not very clear-cut. So, for example, is the result of the referendum constitutionally binding? And the answer to that has to be, it depends on your viewpoint. Generally speaking, it was proclaimed even before the referendum was held that the result of the referendum would be advisory and not binding. Now, this is actually quite a complex area which I don't have the time to go into, because the United Kingdom, as you know, does not have a written constitution, or at least it does not have a constitution which is written in a single document. It does have parts of the constitution which are written down, but not one document like the Indian constitution to which you can refer. So that is one of the issues. The second, of course, is can the result of the referendum be set aside or overridden by Parliament? And that to some extent became the crux of the case that went to the Supreme Court of the United Kingdom, about which I'm going to talk in a few minutes. So that is again a very important aspect of the whole debate, a very important legal aspect of the whole debate. And then of course, there is the rather intriguing but interesting question, which is, can a future Parliament reverse the outcome of the referendum? For example, by mentioning the reversal as a manifesto commitment during the next election. So if you had a general election and one of the parties said, it is our intention, if we are elected, to put a stop to Brexit. In that case, what happens? Very intriguing question, and in legal terms, it has profound consequences. So the long and short of what I'm trying to say is that there is a lot to play for in terms of the legal arguments. Now, in terms of parliamentary sovereignty, an attempt was made in the immediate aftermath of the referendum to argue that the will of the people had been manifested in the referendum, and therefore there was no need to refer the matter to Parliament. In other words, people have spoken, and that's it. So get on with Brexit. But that was challenged both politically and legally. And I'm more concerned with the legal aspect because the title of my talk is Brexit, the Legal Dimensions. So I'll focus on that aspect of the matter. And the legal challenge came by way of an application for judicial review brought by a number of people, but essentially a banker, as it happened, a banker of Indian origin living in London. She argued that Parliament should have a role to play in the implementation of the referendum decision. Now, as I said, the rival argument is that Parliament need not be consulted because the people have spoken. What better way of finding the will of the people than letting the people speak directly? So why go through Parliament? But that was not what some people thought should be the case. So Mrs. Miller, Gina Miller was the name of the lady. She brought a challenge. She was supported by a hairdresser, I think of Spanish origin, who was a permanent resident in the UK, Dos Santos. And they both went to the High Court in England for an order compelling the British government to refer the matter to Parliament. So that is, if you like, the background to that particular case. Then, of course, there were interventions from the Northern Irish and Welsh and Scottish parliaments or assemblies, which are not terribly important, but which still formed part of the litigation. And the central question there was whether parliamentary approval was needed to trigger the exit process. Because you know that although the people have voted to leave the EU, there has to be a legal way of achieving that result. And the legal way of achieving that result was through the triggering of what is called Article 50. Article 50 of the Lisbon Treaty. Now, the European Union consists of many treaties. One of the fundamental treaties was the Lisbon Treaty, and Article 50 of that treaty allowed any European member state to withdraw from the Union. So it gave a legal route for coming out. And that legal route was Article 50, which meant that the British government had to give notice to the European Union, signifying its intention to get out. And there's a 2-year period during which the process of negotiation would take place. Now, the question in the legal challenge was, should Parliament vote before the notice under Article 50 was given? Some people argued Parliament does not have to vote. Mrs. Miller thought otherwise, and the matter therefore went to the courts, started with the High Court in London. What was the government's stand in this? The government said, in view of the people's verdict, what we do is we simply issue a letter under Article 50 of the Lisbon Treaty signifying our intention to withdraw, and that can be done through what is called the royal prerogative. Now, this is something which I'm sure is alien to you because no such thing exists in India. India is a republic, India has a written constitution, and everything has to go by constitutional provisions. But in Britain, there are many conventions, but one of the conventions is that when it comes to matters of foreign policy, then the government, that is the executive branch of government, does have the freedom to take decisions without referring those decisions to Parliament. And that also applies, incidentally, to going to war. So if Britain went to war with any country, that decision does not have to be supported by Parliament, by a majority in Parliament. That's an executive decision which is exercised under the royal prerogative. So the British government said that for us to get out of the European Union, now that we have the endorsement of the public, we do not have to go back to Parliament. We will simply issue a letter by virtue of the royal prerogative. So that really was what the case was all about. Now, the case, as I said, started in the High Court in London, and it was heard by three judges, three of the senior most judges in the High Court in London, and they ruled fairly quickly that parliamentary approval was needed, which means that the government lost the case before the High Court. And the case itself was heard purely on the law. There were no political issues in this at all, because in the public discussion, politics got mixed up with law. But in the courts, and in fact the High Court, both the High Court and the Supreme Court, to which the case went subsequently, were very clear about one thing, and that is the judges will not deal with the political aspects of the case. They will only deal with the law. Now, in spite of that, obviously, the media didn't look at it that way. So the media had a field day criticizing the judges. So much so that there were headlines like, after the judgment came out, to the effect of, the newspapers published pictures of the three judges and said, enemies of the people. Right? In other words, that the judges were trying to upset the will of the people. But that is something which in Britain is considered to be all right, in the sense that the judges accept even that degree of criticism. They're not so sensitive as to say this constitutes contempt of court and therefore let's haul the journalists up. They said, typically that we have broad shoulders, and it just went on. So that is, feel like, the background to what happened after the High Court had given its verdict. Now, the case then inevitably went to the Supreme Court. It was not a surprise to anybody. Now, in our system, the way a case travels through the courts is that we have an intermediate court, which is the Court of Appeal. So normally, if a case is to be appealed from the High Court, it would first go to the Court of Appeal and then to the Supreme Court with leave. There is no automatic right of taking appeal to the Supreme Court. In this case, because it was a very important case, the courts decided to use what is called a leapfrog process. That is to say, avoid the Court of Appeal, go straight to the Supreme Court, which is acceptable, which is totally legal. Also to save time, because remember, a decision had to come very quickly, since Brexit was a matter which could not have prolonged or could not have been extended indefinitely. So the case went to the Supreme Court. The Supreme Court, as you know, is a relatively new institution in the UK. What used to exist before was the House of Lords as the Court of Final Appeal. The Supreme Court is a relatively new creation. So what happened there was that in an unprecedented decision, all the judges of the Supreme Court decided to sit on the bench to hear this case, to hear this appeal. 11 judges, all sitting to hear this case. And the case was heard over a period of 4 days. 4 days only. A case of great constitutional moment. I mean, I think I would be not unreasonable in saying that if you had a case of that sort here in India, it would have, the arguments alone would have gone on for a good 2 or 3 months. But for 4 days, everybody being limited to a fixed duration to argue their cases. Of course, there was very good preparation. Everybody had their papers prepared in advance. Everything was properly documented. So the legal arguments were very focused. And remember, there were many lawyers arguing this case. So each lawyer had been given a certain amount of time. Half a day, 2 hours, 1 hour, half an hour, depending on the extent of their involvement with the case. And the case, of course, was heard only over 4 days, no extension of time. It all went to plan. And the proceedings were telecast live. So you could actually see what was happening in court. which for the Supreme Court is not unusual. Of course, we don't have televising of courts at the lower levels, but Supreme Court proceedings are televised, but not live. This time it was televised live. And you could see, and of course, there was tremendous interest, both on the part of the media and the public. So much so that there was no space in the courtrooms. And there was a spillover room with a TV screen, etc. Not even all the lawyers could be accommodated in the court. The lawyers who were involved in that case could not be accommodated in the case. Only the key lawyers were around, and they argued the case very well. I would commend you. I would commend you the proceedings. You should look at them. If you're interested in constitutional law, it is a feast. Just for the arguments, regardless of whether you agree or not. The arguments were very well presented. Of course, there was a lot of give and take between the judges and counsel, but no needless interruptions, all very well done, with great decorum. So I would ask you, if you have the time and the inclination, to look up those proceedings. They are on YouTube, they are on the site of the Supreme Court, UK Supreme Court. Very easy to Google the proceedings. Now, judgment was given fairly quickly after the case had been heard. The judgment actually came on the 24th of January of this year, and it was a split decision, 8-3. 8 judges ruling that Parliament had to have a say in the triggering of Article 50, and 3 judges saying no, it was enough for the government to use its royal prerogative. And that verdict was, of course, the subject of much comment in the media, in the public domain, and in professional circles. Now, in terms of the legal issues, really what, in simple terms, we could say is that the European Union, or Britain's membership of the European Union, was premised on a law called the European Communities Act of 1972. So when Britain joined the EU, or at that time it used to be called the EC, European Community, then the British Parliament had to pass a law which was called the European Communities Act of 1972. And that law provided for legal effect to be given to all laws passed by the EU at that time and subsequently. So anything that happened afterwards would also be deemed to have the same effect as law that existed on the date of the enactment of the 1972 Act. And it was argued that the rights which had been conferred by such legislation could not be taken away by the government using the royal prerogative. So this was the argument, if you like, for Mrs. Miller and her compatriots, that there were a number of rights that had accrued to the people, and those rights could not be taken away simply by use of the royal prerogative. Because Parliament had enacted the 72 Act, Parliament had to enact subsequent legislation to take the rights away. I hope you understand the argument. It's a technical argument, but it's a very important argument. And that is, if you like, what the applicants in that case strenuously argued. Now, what is the royal prerogative? The royal prerogative, in very simple terms, is the residue of all powers that had been left with the monarch after parliamentary democracy came to Britain all those centuries ago. You know that Britain had a monarchy which was an absolute monarchy many centuries ago. But when we had the advent of parliamentary democracy, then Parliament began taking most of the powers from the Queen or the King. But some powers still remained with the monarchy. And those powers are called, those powers together form the royal prerogative. And as I said, the making of treaties, the going to war, etc., are part of the royal prerogative. And the government, of course, argued that there is no compulsion, because the European Communities Act did not specifically say that in these circumstances parliamentary approval had to be sought, therefore there is no need for parliamentary approval to be sought. That is the argument of the government in this particular case. The other side argued that yes, it is not said expressly, but on the other hand, because it's such an important statute, the onus should be on you to show that parliamentary approval was not needed. So in one sense, the issues are fairly clear, fairly simple, but it makes a big difference in terms of the outcome. So what Mrs. Miller and others said was to the government, show us where in the 72 Act or subsequent legislation it says that parliamentary approval is not needed for big decisions like triggering Article 50. And the other side said, show us where in the 72 Act or subsequent legislation parliamentary approval was needed positively. Neither side could show it. Ultimately, it's a question of judicial interpretation of that particular legislation and subsequent legislation. Now, the other way in which Mrs. Miller put her argument was that there were certain rights which had been given to EU citizens, including UK citizens, which could not be taken away, without parliamentary approval. Now, do remember one very important aspect of the British system, and that is Parliament is supreme, in a way that in India is not the case. In India, you have constitutional supremacy, because you have a written constitution, or a constitution written in one document. But in Britain, whether you like it or not, the situation is that Parliament is supreme. So if the British Parliament decided consciously and explicitly to say that a certain right of the citizen should be taken away, then that is law. You may not like it, but that is law. Of course, you could argue that there is something else which will come in the way of any such legislation, and that is the European Convention on Human Rights. I don't deny that, but that is not because of the EU. That is because of a completely different system called the Council of Europe. They are two separate bodies. The Council of Europe is a much larger body than the European Union. The European Union is about 28 members, whereas the Council of Europe is more than 40. And it includes countries like Russia and Turkey and all that. Now, the European Convention on Human Rights is less, in legal terms, less strong than legislation passed by the European Union. But regardless of that, the point is, in terms of domestic constitutional law, the British Parliament is still sovereign. So if Parliament wanted to take away rights, the argument on the part of Mrs. Miller and others was that there should be an express authorization of the taking away of the rights by Parliament, which of course they argued did not exist. Now, there were different types of rights which in that context were seen to arise. So first of all, you had rights which can be replicated in the UK after the UK left the European Union. So you would have, for example, laws like health and safety laws, or the Working Time Directive, which meant that people can't be compelled to work for beyond a certain number of hours every week. Now, those laws can be replicated in the UK. So what happens is, when Britain leaves the EU, then whatever existed before can be adopted by the British Parliament, and therefore it becomes part of British law. That's one set of rights. The second set of rights would be, again, EU origin rights, that is, rights which originated in the European Union, which are enjoyed by EU citizens in relation to their activities that they are able to enjoy as a citizen of another member state, that is not the UK. So, for example, you know that Poland now is a member of the European Union. So if a Polish citizen comes and lives in the UK, he enjoys certain rights by virtue of EU law, which the British government has to respect, whether they like it or not. And that, of course, also is a cause of some friction in the UK. But regardless of that, those rights have to be exercised. Now, the difficulty with those rights is that if Britain decides to leave the EU, then those rights are going to be taken away, because the Polish citizens in the UK enjoy those rights by virtue of the membership of their government and the British government in the European Union. So one of those connections is going to be severed. So that's, if you like, the second category of rights. The third category of rights is EU rights that cannot be replicated in the UK. And that's a small but important category of rights. Frankly, there's not much of a dispute about these rights. a simple example would be for a British citizen to stand for election to the European Parliament, which now he or she can do because the UK is a member of the European Union. But they cannot do that once Britain quits the EU. And the argument put by Mrs. Miller and others was that, look, that's a precious right. Okay, not everybody uses that right, but it is an important right, and you can't take away those rights without Parliament being asked to approve of it. In other words, what they're saying is, we don't mind if the rights are taken away, but we want Parliament to expressly approve of the taking away of those rights. As I said, it's a technical argument, but it's something which the courts did accept because they thought that rights are far too important for people to be deprived of without parliamentary approval. Now, the argument which the government advanced in this context was essentially that Parliament is, of course, involved. Parliament was involved when it made the 1972 Act, and at that time, Parliament could have inserted a provision in the 72 Act which said that subsequently, if any rights are to be taken away, then the government has to come back to Parliament. It did not do it, and therefore, what are they complaining about? And again, it's a plausible argument, but one which is probably, or does probably have as much appeal as the argument on the other side. So you can imagine the plight of the judges. They had to weigh one against the other. And the government's main case was that there is nothing explicitly saying that Parliament had to approve a taking away of the rights, and therefore, because Parliament is supreme, otherwise, therefore, the fact that you had a referendum and it showed that the will of the people is manifested in a certain way, that should be respected. One more argument that the government made was this, that regardless of what happened with Article 50, the fact remains that at the end of the process of negotiation, whatever agreement is entered between the UK and the EU about the exit terms, that agreement has to definitely come back to Parliament, because that is something which will have to be implemented in law for the future at the end of the 2-year period. And therefore, Parliament is anyway going to have a say. So what are they complaining about? And that, quite frankly, is quite a strong argument. But the court said, no, that's not enough. It is true that that is going to come back to Parliament, but that is not enough. And what we need is something slightly stronger. And the court's response, therefore, was that the government should seek parliamentary approval. The government actually had already prepared for this verdict. So they kept a bill ready, and the bill was just a very short one, just a couple of clauses, which said the government can trigger Article 50. And that was passed, as it happens in Parliament. Because remember, if Parliament went against the will of the people, there would be a huge uproar. And MPs would get a lot of flack from their constituents, because the constituents had voted in a certain way, and how could Parliament vote in any other way? So that is really what happened in terms of the outcome. Now, I'm just wondering in terms of time, I'll probably wind up shortly. What then are the lessons that can be learned from the main issues? Essentially that in matters like this, there is a lot of scope for judicial interpretation, and you therefore need judges of both caliber and wise judgment. It is not something that can be lightly treated, and that's why I said if you go to the recordings of the hearings, you'll see the acute engagement between the judges and counsel, and also their appreciation of the very serious arguments that have been put forward by the various lawyers on behalf of the various parties. Now, just as an aside, I think I mentioned earlier that the assemblies or the parliaments of Northern Ireland, Wales and Scotland had also been involved in this litigation. Their argument was, because of the split vote, and also because to some extent powers had been devolved to those assemblies. Now remember, Britain is not a federal system, not yet a federal system, but it is becoming more and more federal, in that the Scottish Parliament now does enjoy certain powers which it did not enjoy in the past. Likewise, the Northern Ireland Assembly and the Welsh Assembly, in that order. The Scottish Assembly is more powerful than the Northern Irish Assembly, and the Northern Irish Assembly is more powerful than the Welsh Assembly. So there's an asymmetry of powers, but still powers have been devolved. So what the respective assemblies and respective devolved bodies said was that because of the nature of this decision, which is quite far-reaching, each of those assemblies should also have a say on whether Britain should quit the EU. In other words, almost a veto on the part of those assemblies. Now that was, of course, a very serious argument, which was decisively turned down by both the High Court and the Supreme Court. So on that issue, the government won hands down, that there is no need for these devolved assemblies to vote on the question of whether it is right and proper for the UK government to consult Parliament before it decided to withdraw from the European Union. Now, what can happen if Brexit goes ahead in terms of EU law? It is a point which is very important, because you can't simply abandon everything that has happened before and hope for the best. That would be disastrous, because we have for the last 40 years been governed by EU law, increasingly potent EU law. Now in those circumstances, the government cannot simply say we cut everything off, because much of that law has already been incorporated into domestic law. And so it requires a lot of very careful thinking, which is what the government is doing at the moment. And the government has indicated its intention to keep most of the EU law as it is on the date of exit. So there will be a law. There's actually been a bill published very recently in the last 2 or 3 weeks, which is called the Great Reform Bill. Now that bill says that much of the EU law that exists in the UK will continue to hold the field after Britain comes out of the EU. So to that extent, people are not going to be necessarily disadvantaged. A lot of the laws, I was telling you earlier about the EU Working Time Directive, health and safety laws, those sort of things will continue to be the case. Then there is the question of what happens if the Brexit is a soft Brexit or a hard Brexit. If it is a soft Brexit, then the question is, to what extent would matters like immigration continue to be determined by EU law? In other words, free movement of people. That is a very important cornerstone of the EU system. You cannot be a member of the European Union now without giving European citizens the right to free movement. Free movement means free movement. Anybody can go from any part of the EU to any other part and settle down and not only work, but also claim benefits. This is probably what causes more heartburn in some circles. Now that is, if it's a soft Brexit, there is a possibility that that right of free movement would be preserved. But if it's a hard Brexit, then that would be cut off. And then the question is, what happens to those people who are already, those Europeans who are already in the UK? Do they have to go back to their respective countries? Because they're not British citizens. And also equally, what happens to those British citizens who live in other EU countries? Do they have to return to the UK? Very tough and difficult questions, because it also involves economics. Now, a British citizen living in Spain, and there are many hundreds of thousands of retired British people living in Spain who avail of Spanish benefits, so hospital treatment, etc., would be accessible to them, which, if there was a hard Brexit, would not be accessible to them. So there are issues like that which will have to be determined, and that's where the debate is at the moment. It's not at all clear what will happen, and of course there's a lot of shadow boxing on both sides. As you can imagine, in these kinds of negotiations, there is a tendency for those involved to play poker. You will have to do that, and you will also have to sometimes take positions which you may not necessarily want to implement. But it's all part of the negotiation process. So we'll have to wait and see what happens. Now, in terms of very broad conclusions, and I want to just wrap up with that, the stated objective of the United Kingdom, of the UK government, is of course to have an ordered exit from the European Union. But the fact remains that a messy divorce is quite likely. There will be a certain amount of acrimony, going by what one hears already. And of course, in legal terms, there will have to be a new legal relationship established between the UK and the EU, which will be also problematic, but which is not unmanageable. It means that people will have to adjust themselves to the new reality. On the other hand, Brexit can also be a boon in that it offers the possibility of strengthening Commonwealth links. And that's where countries like India come in. That if Britain gets out of the EU, then there is a greater chance of Britain's aspirations to be a better member of the Commonwealth coming to the fore. You know that when Britain entered the EU, Britain effectively turned its face away from countries like Australia and Canada, which they have not forgotten yet, because they consider Britain to be the mother country. And then for Britain to turn away from them and embrace the European Union is something that did not go down very well in many countries. So I think at least in terms of trade, for example, there are very good possibilities within the Commonwealth. And so to that extent, the possibility of greater engagement from the British side in the Commonwealth and the wider world would, I think, be much higher. There's, of course, also, again in legal terms, the potential for the regeneration of English law. Very important, because English law has fallen under the shadow of EU law for a very long time. I'll give you a very simple example which is very telling. There was a law passed by the British Parliament called the Merchant Shipping Act some years ago. This law said that the exclusive economic zone that Britain has, territorial waters that every country has, 20 miles, 200 miles, whatever, the fishing rights will be confined to British nationals and not foreigners. Now, a lot of Spanish trawlermen, Spanish fishermen, used to fish in those waters, mainly near Scotland, where there's a lot of good fish. And they objected to this law. And they said this law, although remember this is a law passed by the British Parliament which was entirely legal by British standards, but the Spanish trawlermen objected to this law and argued that that law was contrary to European law, and therefore that law should be struck down effectively. So this matter went to the court, and obviously it went to the European Court of Justice, which is the court that determines disputes of this kind. And the European Court of Justice ruled that British law should be disapplied. So where is parliamentary sovereignty here? Gone. Gone completely for a toss. So Britain had to disapply its own law, its own sovereign law. And in those circumstances, when Britain exits the EU, there's a possibility of that shackle being removed, and therefore British law, English law, will probably see a regeneration. And my concluding thought is a point I made at the beginning, and that is that it also, this whole process of Brexit also offers some valuable lessons for other countries, other blocs that may be emerging in terms of political or economic unions. I'll stop there, and I'm more than happy to take questions. Thank you very much.
Okay, if anyone has questions, please raise your hand. Okay, so I can see 3 hands, Lovish, Turab, Priyambada. So who wants to go first? Just see if that works, otherwise we'll pass the mic around.
Hi, good evening, sir. Thank you very much for the talk. My name is Lavish Kark. I'm from the 4th year. So my question is, keeping in mind that the repeal bill has now been introduced and Theresa May is keen on waging what can be called as the new war on terror, how do you think the refugee protection paradigm, which was earlier promised under the European law, that would unfold after the Brexit and after the repeal bill?
To predict the outcome. Frankly, it's very difficult to see how that is going to develop because, A, it is not entirely clear what kind of Brexit is going to happen. As I was telling you, if there is going to be soft Brexit, then the right of free movement will, in some form or the other, continue. That is on the immigration side. And you need to separate that from asylum, from refugee status. Britain has had the advantage of being an island nation and therefore, to some extent, naturally protected from influxes of refugees. But then remember that Britain has a border with a land country, and that is Ireland, where I live. Thank you. So that cannot be lost sight of. What can happen is, if there was hard Brexit, logically, the border between Northern Ireland and Ireland will have to be made a hard border, which it is not now. Now when you move from one to the other, you won't even know that you've gone to the other country. It's just a straight road. The only way you'll find out is suddenly the road signs change, the speed limits change from miles to kilometers or vice versa. That's the only way you know you have entered the other country. Now that will have to be determined. But there is a bigger issue in terms of refugees, and that is the porous border on the southern fringe of Europe, which is where most of the influx comes in. What is the European Union going to do about it? Now, many people argue that this system at the moment is shambolic because there is a convention within European law which says that anybody who comes to claim asylum has to claim asylum in the first country in which they land. That is being flouted in a very big way because there are people who actually plan their journeys so meticulously that they ultimately want to come to London. And they go through at least 7 or 8 countries before they reach London. They will not claim asylum in any of those countries. They're all safe countries. France, Germany, any of those. So you do have a problem, and the British people are fed up. I wouldn't say everybody, but a substantial number of people are fed up with this prevailing situation. Why cannot a genuine refugee settle down in Germany or France, or even further south where they enter, if they're genuinely fearing persecution, which is what asylum is all about? So it is a very tricky question. Quite frankly, the answer will lie in whether there is enough political will to tackle this issue on a fair but firm manner.
Good evening, sir. My name is Turab. I am a student of LLM. So my question is that Brexit is only a small step, but then it's part of a large event where we have appointment of Donald Trump, then Marine Le Pen's activities in France. So like that, there are many anti-global populist sentiments going on. So whilst we were calling the world a global village few years ago, things seem to be World War II like now. So where are we heading?
I nearly expected the question about Trump, so I'm not surprised. I must confess I'm not minded to be so apocalyptic as your question seems to suggest. Yes, there are issues, there are problems, there are challenges, but at the end of the day, there are also correctional mechanisms. In both the United States, the UK, and therefore I'm not entirely sure that this is going to necessarily end up pear-shaped. There will be temporary setbacks, there will be problems, And do remember that there is this wonderful thing called democracy, which means that people who think they are invincible and can go on forever might be turned out at the next election. Not impossible.
Hi, my name is Parika. I'm a fourth year student here. Sir, my question is, so if media was at a one of the major reasons for it was lack of jobs or because of EU. So in that light, a migrant issue becomes extremely sensitive because have a soft Brexit that defeats the purpose of be extremely difficult for migrants from both sides. So what do you think is a probable case scenario, and if the parliament really wants to appease the citizens, then they would ideally go for hard Brexit?
I want to go back to the point I made earlier, namely that we cannot be entirely sure whatever Brexit is going to emerge. So with that caveat, to answer your question, the situation can actually be redeemed, if that is the word I'm looking for, by a fairly sensible approach to the issue of immigration. And already there are many people who are arguing that by going for a hard Brexit, the shutters are not going to come down completely. Why? Because the alternative of ordered immigration or an ordered immigration policy is still open. For example, there are many people in Britain who are advocating a good points-based system for talented people to come in. And there will always be a need for such people, because at the end of the day, European countries do need outsiders. There is a declining population, there are so many other things happening, skills shortages, etc. What is happening at the moment, according to people who are very unhappy with the situation, is that you are getting the wrong kind of migrants. You do need migrants, but if you have a points-based system which is fair but firm, then there is a possibility that you will get the kind of migrants that countries like Britain need. And I think it's feasible, because if you look at what's happening in Australia, they have managed to strike a decent balance, not perfect, but a decent balance, and that may work for Britain as well.
Good evening, sir. My name is Ajoy from the third year. With regards to your answer about the cultural implications and the maybe a little the racist implications of a Brexit, and your answer with regards to the systematic mechanisms that you seem to have trust in, over the last few years, I personally cannot help but look at the world and refer to your answer as seemingly optimistic or idealistic. So I was just wondering, in a broad sense, where this trust in a systematic mechanism comes from over here, because the evidence for it seems to be limiting every day.
Do you have in mind a systematic mechanism for immigration, or more generally?
Immigration also as a part of a larger issue of xenophobia and racism.
Right, okay. Now that of course opens up a can of worms, because if you're talking about xenophobia, racism, etc., then you need to also discuss a number of other factors which would probably be out of the remit that we have here. But the fact is, many of these things are cyclical, in that, you know that in the 60s and even 70s, Britain had some figures who were very hardline on immigration. Enoch Powell comes to mind, right? I'm sure you've heard of some of the speeches that he made, which many people considered to be over the top and bordering on xenophobia. But do remember that that gave way to something so different in terms, for example, of the Blair government's policy of, at least in effect, open borders. So these things are cyclical. Secondly, I think in a democracy, there are self-correcting mechanisms. Do remember that Britain is a very tolerant country. Now, I know that from the outside, you may not necessarily appreciate that. But believe me, there is a lot of tolerance and a lot of goodwill among the British people for outsiders. And Britain has always been, in that sense, quite willing to accept strangers in their midst. There are a number of issues here which we don't have the time to go into, because you could also then begin to talk, and this is a very sensitive issue, of the responsibilities of immigrants. That, to some extent, also is relevant to the discussion. I'll give you a tangible example of what is happening here, which has angered many people, and that is, if you have a situation where somebody comes in, say, from Eastern Europe, without guaranteed work in the UK, and they have a right to come in. So they come in and they derive social security benefits, which are fairly generous. They can actually send money back home for children, child benefit, which would be payable to their children who live in Poland, not in the UK. Now, a lot of people consider that to be very unfair. And if you had many such policies in place and they multiplied, then it would not be surprising if there's a degree of xenophobia, if you want to call it that, or at least a degree of lukewarmness towards open borders. That's what I'm saying. I'm being very careful in the way I put the argument. And I'm sorry if I sounded idealistic or optimistic. It is simply that I have to be fair in the way I put the arguments. I do think that the situation is not quite as dire as some doomsayers have predicted.
Maybe you can just speak up.
Good evening, sir.
Good evening.
So, talking about the economic rights of the EU people and the citizens, sir, you take the example of fishing right of the French, other European country people in the territorial water of the Britain. Sir, at the same time, it also gives the British fishermen a right to have the fishing right in other territorial water of the other EU members, sir. So, at the same time, it also play the level playing field for the EU and not to take the disadvantage of one country at the expense of other. Sir, don't you think it's create a level playing field? And sir, my second question is, in case of globalization or unification of the economy, when we talk about the globalization, it's a free flow of capital. Why don't we promote also the free flow of the labor? It is what the third world country have. Okay, thank you.
Yes, not easy challenges to overcome. On the first point, one of the things that you'll hear if you read the literature on the subject is that although in theory you have reciprocity, that is, British fishermen can go and fish in Spanish waters, in practice it doesn't quite work that way. I'm just drawing your attention to what exists in the literature, okay, without necessarily endorsing anything. And that is that one of the themes that has emerged in the last so many years is Brits, generally speaking, play by the rules, whereas a number of other Europeans don't. Now, I know it's probably being partial or you know, in a way disparaging of the others, but this is a reality which we are told, and I'm not a fisherman, so I don't know what the reality is, but we are told that is the case because there is a lot of if you like, disobedience of the rules on the part of certain countries. And in those circumstances, if you alone play by the rules, then you are at a disadvantage. That's one of the arguments. And secondly, there are also issues of whether the whole of fish that you get elsewhere is quite the same as you get in your own waters. And remember, the issue of proximity is important as well. If you're a Spanish fisherman, why should you be compelled to go and fish in Scandinavia? or Southern Europe. So there are issues like that, and I think on the whole the concept of sovereignty is still a strong one. Why is it that India so strongly, and in the eyes of many people rightly, insists on Kashmir being part of India? I'm not raising a controversial issue. I'm just saying the concept of sovereignty is something quite strong in the minds of people, in the hearts and minds of people. And therefore, to that extent as well, the debate over issues like Brexit is colored by that very potent idea. The second issue you raised about free movement of people, yes, superficially what you say is attractive, but believe me, if you applied that principle, there will be serious difficulties because, let me give a practical reason. Britain is a very small country and an overcrowded country. You may not believe this, but it is an overcrowded country for its size. The population density is very high. Now, in those circumstances, if Britain allowed free movement of people, and remember, this is also tied with talents, with ability to work, and so many other issues, then in practical terms, it's not going to work. Although that does not mean you stop people at the borders. As I said, if you have an ordered system of immigration, which every country has a right to, India has a very strong immigration control system, incidentally. That is something which is accepted all over the world. So, for example, you have a problem with the border with Bangladesh. Immigration is a very potent and sensitive issue. So every country does have those kind of issues, and therefore I think it will be probably unrealistic to expect the free movement of people to go exactly the same way as free movement of capital. There will have to be reasonable restrictions and controls imposed.
Okay, so in the interest of time, we'll close there. Dr. Venkat Iyer is here for a few hours. He's here tomorrow morning. So in case somebody has pointed questions or direct questions, maybe immediately outside the corridor.
Certainly.
On behalf of Nalsar, I thank him for taking out the time to come here. And he gave us a fairly systematic and structured discussion on the judgments which arose from the Brexit controversy. For some of the older students, it might have been familiar territory. For some, perhaps not. But certainly since we've recorded the transaction, you can obviously go back to this material and have a more informed discussion the next time we are bringing this up, right? So year 3 and LLM students, we'll take a roll call for you. The rest, for you, the detention is over.